Good evening. We are back with the IP Business Talks. It's Wednesday again and 5 o'clock Central European summertime. Be careful, on Sunday we shift the time here in Europe. We have the same format. It's a live format, and that means we can see what you chat parallel on LinkedIn. And we are absolutely happy when you write questions or comments. I will pick that up and ask our guests these questions. And so you can use really this time here with us together and be part of that discussion. So this evening we have a premiere. That's the first time that one guest is the second time with us. So Malte Köllner is twice here. He was the first guest, and I'm very honored that he was willing to come back. And that has a lot to do with the topic which we want to talk about today. It's generative AI, and it was 2020, so around 3 years ago when we had the first talk. And in that time, 3 years ago, it was a bit strange to talk about this computer-generated inventions. Yeah, so generative AI was far away from the normal experience of IP experts. So that this world has changed completely in November 2022 with the first public offering of ChatGPT, and since then we live in a new time, in a new era, and that's obvious for everybody who is dealing with that things. And as I said, many years ago, Malte already worked in that field and made experience in that field. And I would say, in at least in Europe, he is one of the experts with these topics of computer-generated inventions and all the issues which come along with that topic, finally with the whole IP system. So I'm very happy to have Malte here. And first of all, Malte, thank you very much for joining us. And please explain us a little bit about you, about your background. So what you're doing, and especially why you became a patent attorney.
Yeah, thank you, Alex. Thank you for having me. Thank you for having me a second time. So it wasn't too terrible the first time. Yeah, you said I should take some time to tell the story of how I got into that. Yes, as you said, I wasn't born as a patent attorney, and my father wasn't a patent attorney. Actually, my father was a policeman, and I studied physics just like you. And do you remember when we met first time? So really met, Alex?
Not really. It's too long ago.
Yeah, you were too drunk, actually. Yeah. You were driving me in your car from Wismar to Hamburg.
Oh, Scanbald.
Yeah, you remember that. And that was a terrible ride. I mean, we understood each other. And we were talking about didactics and how to explain things to people. You were at university. Have I been a lecturer then? Maybe I was, or maybe not. And then both of us, we were working on, you more than I, probably, obviously, we were working on patent valuation back then. And you challenged me, and you told me, okay, give a talk. And I gave a talk and thought, it was terrible. That's just rubbish. I was talking rubbish all the time. There must be something better. And I found something better. Do you remember that? Probably. Now, yes, how did I get into that? Well, I became a patent attorney because I wanted to leave university, and I didn't know what a patent attorney is. And a friend of mine said, "Why don't you become a patent attorney?" And I said, "What's that?" Okay. Well, I mean, how did it come along? I'm a lecturer in Strasbourg in your SAPI program for patent valuation because we developed that. And then there is this alumni organization called I3PM, which bring together industry and academics and so on. And they had a conference in Strasbourg. And you invited Professor Ryan Abbott. And Ryan Abbott gave a talk about what it means if inventions are generated by artificial intelligence. Not necessarily some fancy artificial intelligence, but things that actually exist today.
That was 2018, right? 2019.
That was, 2018 probably, because I went home and I discussed it with a couple of friends, and I said, perhaps I'm editor-in-chief of a journal, so I know a little bit how to create awareness for some topics. And I said, there's no point in any professor writing another article about this. What we need to bring this topic on the table, what we need is judgments by courts, by important courts, like Bundespatentgericht, Federal Patent Court, or maybe CFC in the States or whatever, important courts, and then it will be discussed. And how do we get there? We have to file an application. And how can we find an application? We have to find somebody who has a machine that generates inventions and that needs a patent application for these inventions. And then we will file a patent application for that person, and we will simply name the computer as inventor.
And this is this Davos project, right?
That is Davos, the person that when I called Ryan, and then Ryan found somebody called Stephen L. Thaler, and Stephen had this machine which he later called Davos, not in the beginning, but later he called it Davos, and that generated a couple of inventions. And we said he was very interested in having patents granted on inventions generated by his machine. That would make him very proud. And also it was very, very important for him that he did not consider himself an inventor, but his machine. Whether you agree or I agree or courts agree is another matter. But that was his view. The inventor is his machine. And so we said, okay, let's do it. And very likely patent office will refuse these applications, and we can go to appeal, and we will have a judgment. And that was the aim of the project. And then it will be discussed.
Let's jump into this topic. What would you say? What are the practical hurdles when it comes to handling IP for inventions? So IP, I mean, we talk about patents for inventions which are created by generative AI. What would you say? What are the most important hurdles? Because there are many, I guess.
Well, probably not an infinite number, but it's actually up until today not clear how to file a patent application on such an AI-generated invention without lying. And that was one of the things we wanted to achieve, find a solution without lying. Because computer-generated invention, software-generated invention, AI-generated invention, however you call it, they've been around for a while. In optics, in other areas, people had programmed things that were able to create solutions, mechanical structures, whatever it is. There's a lot out there. And what they did is they lied. They lied.
Yeah.
One sentence. They named a natural person that actually didn't invent the thing.
Maybe we should start one step before I hear out there, especially on LinkedIn again and again, that this phenomenon does not exist. I mean, it exists on a quite a scale. So we have lots of tools, mechanical engineering, as you said, chemical engineering. So I made a post about a company which were developing drugs with artificial intelligence. So it is enzymes, proteins, whatever. That is important for the audience to understand. This is not an academic discussion here in terms of what will happen when we have AI which invents. This is a day-to-day problem, and exactly what you said. I mean, the only way so far was lying.
Yeah, but we're really talking about today. What we have in most cases is niche solutions for particular applications. Somebody built something that is able to solve a certain class of problems. So that is the rule today. But it's also been the rule 20 years ago. But these things are here today. Do you know the German company Symrise? I think they entered the DAX and they produce aromas and perfumes and so on. And I think they have a machine for designing perfumes. These are the things that exist. They exist today. It's really a practical problem of today. How shall we deal with these applications? Well, it then turned out to be extremely academic too, because loads of PhD theses and professors wrote articles and so on and so on. But it is very practical. These things exist, and it is not very clear how to handle these. What people did in the past, because they didn't know anything better, they just lied. They picked some natural person and they kept quiet about the role of the machine, and that was it. And we said that's actually not such a good plan. We want transparency about the role of the machine. And so, of course, it was a provocation to name the machine Dabus as inventor to the patent offices. Obviously, I mean, they refused for probably not so very good reasons, but at least the discussion was going on.
But I mean, some people out there argue that, naja, the AI has the role as a typewriter, and it's a little bit more so it's like a search machine. So they use analogons to say at the end it's always the human. The human asked the question, the human prompt, the human collected the data or said which data should be collected, and at the end it is an intelligent typewriter. So which means it is not lying.
Well, I mean, of course you can. Yeah, you can. I mean, we will get to that, of course. I mean, as most of you know, and also the audience out there, the court said, whatever the machine did, you have to name a natural person as inventor. Even if that person did nothing, nevertheless, you have to name it. But one thing I really don't like is to say these machines are not intelligent. That's just not, that can only say somebody who hasn't seen these machines. I mean, if a machine can beat the world champion in chess and in Go and so on, then some of these machines are terribly good. Yeah, well, I mean, some machines can be a pain in the ass. I don't know if my mobile phone has a problem. I won't like it, but some tools are really good. I mean, let's stay with the example of Symrise. Yeah? Designing a perfume is a complicated thing. And all these interactions of molecules and skin and temperature and moisture and whatever, a machine is, if it's well programmed, is able to take all these things into account at the same time, which poses problems to human brain. So some of these machines are just intelligent, and in some instances, it's the machine who proposes the molecule and not a human being. So the inventive merit, in some instances, to use a patent law term, is generated, performed, whatever you want to call it, by a machine. Sometimes. There is always some human around. There's a human who bought the machine or who posed the problem or who built the machine or whatever. Yes, very, very likely somewhere there's some human being around.
Yeah, I mean, how I try to explain it, because I'm using that, I saw that. So you can train, of course, an LLM like ChatGPT or others, Anthropic or so. You can train them with patent data and about a specific problem or about a specific technology, and then you say these LLM should just use this data, and then you ask questions, you play around, and then these status that the chatbot starts to hallucinate and start to say things which are not represented in the data in that way, and this this status is typically seen as lying or as fantastic stories, but when they fulfill the physical rules, physics in general, you get an invention from that, because it is simply not written or determined originally by the literature which you gave the system. It is something new, and the
Yeah.
system has created it. And when it's an invention, it's an invention. So that's simply a fact. And in that case, I would say the invention, the inventive step here comes from the machine.
Yeah, absolutely. I mean, as a patent attorney, I have to say any technical teaching is an invention. Some inventions are new and inventive, and you can get a patent on them. And some inventions are not new, but they're still inventions. I made a test with Bing AI, very simple, that actually everybody can reproduce. I said, Bing, listen, the handbrake of my bicycle is screaming. And I chose the creative mode in Bing AI. I don't know whether that exists anymore, but at that time it existed. You could be more exact or more creative. And I said, be more creative. I said, okay, the handbrake is screaming. What can I do about it to eliminate that screaming? And she gave me like 5 or 10 or whatever. I said, you can access the web and so on. They gave me like 5 solutions, something like that. And I said, yeah, but this is all known. Give me something that you didn't find on the internet. And Bing did. Bing did. Bing suggested something I don't remember, suggested something it had not found on the internet. Not necessarily a brilliant, economically valuable idea, but something it had made up. And it was a technical teaching, do the following steps, so it was an invention. And everybody out there can do it. Just ask
Yeah,
Bing,
of
or
course.
maybe even ChatGPT.
Yes. That's the trick. It's relatively simple. I mean, it's a question which trading data you use, but when you combine it with patent literature, for example, then you will get exactly what you explained. So the coming back to the problem with the offices. So why do you insist that there should be the machine named? Because some people would say there are lots of machines which were used. Yeah, also the Word. Yeah, or a patent filing and documentation system, whatever, and they are not named. Just the human being. So why do you think that it is critical or crucial to name the individual?
No, it's not. I would say it's not, but I think it would be more transparent. I mean, in many areas, persons skilled in the art will simply know and recognize that certain inventions are typically made by machines. Like who designs an integrated circuit nowadays? I think it's mainly machines, not humans. So persons skilled in the art in different industry sectors can easily recognize that certain inventions were made by certain machines, which they even know. Oh, this is a typical example generated by that machine. And other inventions may not be easily recognizable, may even have been produced by humans. Why not? Yeah. Okay. We think, me and some colleagues who are doing that around the world, we think it is progress if we are transparent. If we just say the things as they were.
And who would you then call the inventor in such a case?
Okay, now the courts basically around the world, with very few exceptions, said the computer cannot be formally recognized in legal terms as the inventor. Only a natural person can be recognized as the inventor. In formal terms, you can designate before patent office on the patent document you will find inventors, a natural person. But there is no ruling until today or whatever, no guidance who that person would be in an example where actually the machine did the thing. But here comes, let me show you a slide, a good slide. Okay, can I? Alex, will you?
Yes, of course.
Okay, here we go. So the traditional way was a human made an inventive contribution and generated an invention. Traditional, yeah? And because he generated that invention, that person was called inventor. And he was the inventor of that particular invention. And because he was the inventor, a right to the patent was generated and a patent to that particular invention. And if all this was given, and that's traditional, then you could file a patent application and maybe get a patent granted. What happens today is that the machine generates the invention, but the machine cannot generate a right to the patent. Only humans. The sphere of the humans, the sphere of the right is the sphere of the humans. A machine is a thing. A thing cannot own any rights. So the machine does not generate a right to the invention, and you can't file an application on that and can't get a patent. Okay, what can we do about it? Somehow we have to jump from the invention to the application with some trick, and court said you need a natural person. Now the natural person does nothing or whatever, we don't know, to the invention. Something, but we don't know what. But as it is a natural person, we now have the right to call that person inventor. While the AI machine, we can only call generator or whatever. We shouldn't call it inventor because the term is reserved for natural persons. Now, as we now have a natural person, we can generate a right to the invention, to that particular invention. Then we can file a patent application. The point is, it is totally unclear what that contribution should be. And actually, I would say no contribution would be enough. Typically, you would take somebody who is around. But let me dig a little bit deeper into that. I think I have another slide. Let me see. No, let's jump that. Oh yeah, here, okay. We know we have to take a human. Now we can either take those who created the machine, or we can those who used the machine, or what has been discussed, take those who received the output. Okay, this is kind of a temporal ordering. First you build the machine, then you use it, and then you have a result. Okay, now, who created the machine? Somebody programmed it and somebody trained it. Or maybe the same person or whatever. These are some important steps. On the output side, we have somebody who sees the result from the machine and says, hey, this is really good, let's file an application. And on the user side, you have somebody who said, hey, here is a problem. I think your machine is good enough to solve that problem. It actually was built to solve exactly that problem. Can you ask your machine for an answer? And then there's maybe somebody who knows how to ask the machine. And now here comes my opinion, Alex, my opinion. I don't think that it's a good idea to call a person who recognized the result as being valuable, to call that person an inventor. What the machine put out was an invention before somebody came along, some human came along and said, oh, wow, it's an invention. No, it's been an invention before. So I don't think that's a good idea. Making the programmer or the person who trained it inventor is maybe not for legal terms, but for practical reasons, really not a good idea. Because if you build an AI and you sell it, and that AI generates inventions at your client side, then your employees who built the machine will always be the inventors on the side of your client. That will create endless problems. I don't think that's a good plan. And there's another principle in patent law: somebody who only received orders is not an inventor because that person wasn't creative. So the person who knows how to handle the AI machine isn't the inventor. So there's one person remaining in my eyes, but it's only a personal opinion, the person who posed the problem. So the person who said, hey, we need something against COVID-19. we have this machine. Let's go to the machine and see if we can find something. That
So you
for
would
me,
say, Malte, just to get you right, you would say let's call this person a prompt engineer, okay, who controlled the machine. You would say this is not a job, because I'm prompting a lot, and that's really creative work. And so yes, you have to understand the problem, but especially when you prompt, and when you prompt creative and meaningful, you have also to understand the problem.
yeah, I mean, I said the person who controlled the AI shouldn't be considered the inventor. That is, of course, a bit too harsh a statement. If that person was creative in engineering the prompt, if that person really made a contribution, of course, that person can be a co-inventor or something like that.
Yeah, yeah.
Yes, yeah,
So
definitely.
then it is these two guys. So one person who understand that the problem could be solved with that machine, and understand the problem, and understand that the machine would be able to solve it, and the person who is able to manipulate the machine in a way to interact that the problem becomes solved.
Yeah, well, I mean, most of these machines are not trivial. I mean, ChatGPT is rather easy to handle, but many of the other machines are not.
Exactly. And you really have a deep understanding how it works, what can happen, why things happen. I mean, often we don't know why things happen when it is AI simply, but at least that you understand that that could happen, and that might has happened, and then you change your prompt and you check whether it is so that's quite often not a simple task.
Typically, you would need a training to handle this specialized piece of software. So not everybody knows how to handle
There are
that.
people out there who say AI is as long as it don't work, and as soon as it works, we call it software. But okay, what
Yeah, okay, but whether we call it computer, AI, or software, that doesn't really matter.
or machine?
Yeah, or machine, it doesn't matter.
But there is there are very interesting comments and questions on LinkedIn. I would like to pick one thing up which comes quite often, and I know you have a brilliant answer to that, but I think we should talk about that a minute. There is a connotation on these commands which says, why should a machine wants to have a patent? Okay, so this is an interesting discussion. So that you could say a patent is an award for an inventor. Okay, and and that patents are a certain annotation to individuals, because they are that is the motivation of getting a patent from the inventor. So why should we, however, mention the AI in it?
Okay. Alex, if you take away the slides, I can show you another slide which would give the answer to that. Yeah, okay. Let me, one second, and I will find it. Yeah, okay. If you want, you can bring up the slides again. Okay, here we are. Now, there are these ideas that patents are here to reward the inventor. Now, this is not the case. That's not why we have patents. Patents are here to reward investment into technological development, typically, not always, but typically done by companies, by industry. And that is not what I think, but that is what has been codified in Article 7 of TRIPS, objectives of any patent system, promotion of technological innovation, and so on and so on. You can read it if you like. I will not read it to you. So that is the real background of patent law. Patent law is not here to reward the inventor. Patent law is here to incentivize investment into technological development. And
Okay,
therefore,
so
the machine is not interested in having a patent. Of course not.
yeah,
But the person who bought the machine or built the machine, that person is interested in having it.
yeah. At the end, it is about the improvement of technology or of economy in general. That is what we're looking for, and that's why we have the patent system at all. I mean that is
It's a piece of economic policy.
exactly. Sometimes forgotten, but that is the point. And insofar, your approach is to say we should be transparent, and we should mention that the critical aspect is at least to a significant contribution from a machine. That's what I understand what you say.
You can take away the slides if you like. Well, I mean, there are all sorts of interactions between machines and humans. Sometimes the machine does a bigger part of the job. Sometimes it does a smaller part of the job and is only helping. This is a complete grayscale and everything exists. But there is the extreme, and that, of course, is the thing that is worth discussing. The extreme is that the machine is doing the complete inventive step.
So now we have another very interesting question, and this is about ownership. Okay, so the question concrete is what would that mean when, for example, the machine is the owner? Okay, but what is your perspective on ownership here?
Now, the machine is, as I said, a thing. Under current law, the machine is a thing, and all serious persons do not have the intention to change that, because that's, I don't know where we are going. No, we humans want to rule the human sphere, and we have no intention to give away rights, leadership, or whatever to machines, unless they drive us around or something like that. Yeah. No, the machine cannot own the patent. The machine cannot be the inventor. The ownership is in the human sphere. Either a natural person owns the patent, or a legal person, a company, whatever. And ownership is derived, in patent law, is derived from the inventor. At the very beginning, the inventor owns all the rights, and then they move on from the inventor to his employer and so on. Yeah? So when we want to clarify and be open about the machine, we have to start with the inventor to clarify ownership. And if we get that piece, that screw well done, we know who's the inventor, that's a good choice of human inventor, then all the ownership questions follow up easily.
But isn't it so that the inventor has to make the inventive step? So that's the job from the inventor, that's the contribution. And what you say is that this contribution comes from the machine.
Well, I mean,
or give me a chance. I would say it, what does the inventive step means in this context?
Okay, a couple of aspects of that question. First of all, in traditional patent law, the human would make the invention, and yes, the human would make a creative contribution, an inventive contribution somehow. Yeah, but even in classical patent law, that wasn't always the case, because you could stumble across an invention just by chance, and not have an idea in your mind by chance, but see it on your desk by chance. And that would still be an invention, and you, the one who found it, could file the application and name yourself as inventor without having contributed any inventive step, even in classical patent law. But it's been very clear now in all the Davos discussion, and some courts also said it, the European Patent Office or the German Federal Patent Court, I mean, if the machine really did the inventive step, but we insist on having a natural person named as inventor, then it is clear that this natural person did not contribute the inventive step. So, another question, but that's really a completely different question, is what does non-obviousness, being inventive, mean if a machine created the invention? Is it perhaps, in legal terms, obvious because the machine did it? There's one resolution out there passed by AIPPI, which is pretty good in that respect. And yes, there is a certain development and a certain chance that some courts will say, I mean, the machine did it on Tuesday and it can also do it on Wednesday, for the machine is easy. And therefore, if everybody knows that machine, and we all know this machine exists, and we all know that machine can solve this sort of problems, then there is a fair chance of any new creations made by that machine will be considered obvious.
So, and then the human who saw it on Wednesday is the inventor.
He's the inventor, but he won't get a patent because it's not inventive.
Okay.
He can file a patent. Yeah, because it's obvious. He can file a patent application. He can name himself as inventor. That could one day be legally totally correct, but he's unlikely to get a granted patent because maybe it will be considered to be obvious. Okay, but only
because a machine is known that the machine can solve the problem.
Okay, but if you build a machine on your own and nobody knows it, then it's not obvious to everybody.
Yeah. So you would say the obviousness. So we rise the bar and say everything what a machine can solve, or the public known machine can solve, is not has no inventive step in it.
The American term is obvious, which is quite good at that point, because I mean, in optics, it's been around for 20, 30, 40 years. You have these optic design programs, and every optician knows these design programs, and we all know what they do. So for an optician, it is very clear that you would use the machine and that the machine would generate a certain class of results. So then that could be considered obvious. Actually, in optics, it is an interaction between a human and a machine. The human makes a certain number of suggestions and the machine does the rest. So that's a kind of 50-50 situation.
Mm-hmm. And that leads us to this point, who brings which contribution to the solution.
Exactly. And that's machine dependent. I mean, some machines do more and some do less. That really depends on the individual case. And why is it, Alex, you haven't touched that point yet. Why is it important to be transparent?
Right.
In-house, within a company, it might not feel just to pay the full inventor remuneration if the machine did the invention. I'm not saying this because I want to take away money from the inventors. No, they should receive what they deserve. But many people out there say, but if it was actually the machine, it doesn't feel right to pay the full remuneration.
Okay.
So that in-house, you would like to know how the invention was generated.
Yeah. I have a wonderful suggestion from Johann Nordquist. He says we should make a kind of Turing test. Okay. He said, just ask the machine the question, and so the general known machines are asked the question, and when they are able to solve the problem was not inventive. The solution is not inventive.
Fair comment. Yeah, I agree. Yeah. So the examiner at patent office should have the machine and see whether the machine brings the result.
Like a novelty search. Yeah, you check the novelty, and here you check the inventive step based on these machines. And the machines are state of the art. artificial intelligence machines, and when they come to then they can solve the problem. And when the examiner was able to prompt the machine in a way that the machine was able to answer correctly, there can't be an inventor step in it.
Yeah, but if you fine-tune your own machine in-house, proprietary, gave it some additional data that nobody knows, then it's not obvious.
Exactly. That would be the test. So obviously it is not a common known, everywhere available generative AI machine or whatever, or problem solving machine. It is something specific. So you tuned it with data, with your prompting, with your experience in framing so we have lots of these examples with LLMs that they are jailbreaked simply because you ask in a different way and the machine don't realize that it is the same question but simply asked in a different way. And when you do this kind of tricks to come to the solution, which is more sophisticated than the typical examiner knows how to prompt the machines, that would be a criteria.
Yeah, but these ideas do not rely on case law yet. No lawmaker, no court has ever said anything about that. That is just an AI PPI resolution, which I personally find convincing. I think that these are sound ideas, but it's only suggestions so far.
Yeah. I mean, obviously, when I look I'm not able to, in the early minutes, I thought nobody will ask anything and they're just listening to what we talk about. And now Bernd Haberlander and all of you, Jörg Krebs, thank you very much for these very sophisticated questions. I hope a little bit that I was able to pick it up. Mr. Haberlander, I just read it for you. Your concept of an invention seems to be limited to a technical teaching which a machine, AI or whatever, may be able to produce now or in the future. Yet, an invention appears to include more features, namely a legal entity or object by virtue of which the invention can be owned and disposed of. While consent appears to exist that a human, as a subject which may bear claims and obligations, can create such legal entity concurrently with a technical teaching, this appears to be difficult. So this, I think it is...
Difficult question, also difficult to follow. It was very long. But I think we should... In this Davos debate, I learned that it is very important to dissect the different terms step by step, and not to say an invention involves an inventor who must be a human person. That's three different things that we have to tackle one by one. An invention is...
We have just 2 minutes left.
Okay. An invention is a technical teaching, full stop. Whether somebody claims any rights in it is a next step and a separated step of that. If there's a human who says, hey, this is my invention, then a right is generated, and so on and so on. We really have to dissect the terms and have to be very careful. If the machine says, this is what you can do with your handbrake, it's an invention.
Okay, thank you very much. So then Haris Prasad comes again around the corner and says that this transparency aspect in an in-house setup is very, very tricky. And I can only say yes, of course, like today. And he said it becomes very critical to assess the role of inventors in developing an invention. I mean, this is the daily bread. This is exactly a problem, and it just gets another aspect with the usage of AI. So that would be my position to that.
Can I make one final statement?
Of course, yeah, yes.
I mean, the courts, the patent office have made it clear they really don't care where the invention comes from, with AI, without AI. They don't care. But in-house, you have to know where the invention came from, because at least in Germany, it determines the remuneration. So you have to know how the invention was generated. In-house, but only in-house. not before patent office.
Yeah, yeah, but exactly that is the multi-million-dollar question from time to time. Okay, Malte, we came to an end. I have again the feeling. So now lots of comments, and Maria, thank you very much for your positive feedback. Yes, this is really mind blowing, and yes, we cannot ignore that simply. And we have to solve these issues. And Malte, thank you so much for your commitment, what you're doing at the IP Business Academy in our training programs with the EPO, what you're doing as expert for companies, helping solving that problems. Thank you very, very much for this time and your explanations here. I hope you are also available the next hour. We will answer, and especially Malte Köllner will answer your questions. Dr. Köllner is available on LinkedIn, and we go through that. And I hope that we can clarify, however, as he said, what is problem 1, 2, and 3, and how to separate that things, and how to come to a, let's say, a better educated guess what we should do in these cases. Thank you very much, and have a great evening. And we see us again, I guess, in 2 weeks.
Thank you for the discussion, Alex. Thank you.
Dr. Köllner, bye-bye. Thank you so much.